Thank you for joining us this morning for Sterne Kessler, Goldstein Fax's presentation on Patent Office Litigation Lessons Learned. With us this morning, we have John Covert, who is the Director and the Practice Group Leader of the firm's Biotechnology Chemical Group. He creates patent portfolios in the life sciences and provides counseling regarding patent portfolio strategy with issues that range from licensing, collaborations, and technology acquisition to patent validity, infringement, and design around strategies. Dr. Deborah Sterling is a director in the Biotechnology Chemical Group. Her practice is focused in the biotechnology and pharmaceutical industries, where she is involved in all areas of patent procurement, exploitation, and enforcement. She has served as counsel on approximately 40 IPR and CBM proceedings, including on appeal to the Federal Circuit. Jeremiah Frueauf is a director in the Biotechnology Chemical Group. He counsels domestic and international clients on the preparation, prosecution, and defense of complex worldwide patent portfolios, as well as enforcement of those IP rights. And with that, I will turn it over to John.
So good morning. We're going to start off with a timeline, which people that are familiar with IPRs will recognize, and the timeline has not changed. What we can report is that the Patent Office, the PTAB, is staying on kind of schedule with respect to IPRs and CBMs. And by that, we mean that we're seeing decisions on institution coming out by the 6-month time period, and then we're seeing final written decisions being issued by the Patent Office within a year of institution. What we're seeing with respect to the timelines between decision to institute and final written decision is that some of the time periods for the parties are being compressed in order to give the Patent Office time to write their decision. And so it's making it a little bit more difficult on the parties because they have tighter deadlines to meet. So we've got a bunch of hot areas listed below the timeline, which we'll be addressing today after showing you a couple slides on updated statistics. And these include statutory filing bars, real party and interest, 325D discretion, joinder, priority challenges, prima facie attack, what the proofs necessary to establish a prior art date are, and then kind of jumping into stays, motions to exclude, Estoppel, and some new data that we've seen since a number of cases have now made it through the PTAB and are now going to the Federal Circuit on appeal. And so we have a chart showing kind of the overall IPR and CBM filings by month since the start of IPRs back in September of 2012. We're probably going to have to switch this graph because the overall total is now above 4,000, and it's kind of washing out the red bar at the bottom, which are the monthly filings. And so you can see we've kind of eclipsed 4,000 total in terms of IPR petitions. 18 PGRs have been filed as of February 18th. I know at least one was filed earlier this week. But the take-home message here is that we're holding steady to about 150 petitions per month. And so, this is a process that has kind of become mainstream, and we can expect to see continue. And so, what are we seeing in terms of institution at the PTAB? And if you look at the right-hand table, and you look at the last 5 fiscal year quarters at the Patent Office, you can see that the institution rate has dropped below 70%. And so, this is kind of a sign that the Patent Office or the PTAB is, maybe not a death squad at this point, because the overall cumulative rate is now around 70%. But we've seen over a year of statistics where the number has been under 70%. And so, that deals with kind of institution of a particular petition, which has to go to a particular patent. The other thing we track are challenged claims. And so the last bullet on this slide, the board overall has instituted trial for 63% of challenged claims in IPRs and 62% of challenged claims in CBMs. And so, again, it's something to be concerned about, when one of these proceedings is filed, but, there's still the angst that you have to deal with, but it's not a certainty that your patent is going to go down if you're the patent owner. What we have seen and is holding is that the statistics in the life sciences tech center 1600, are continuing to differ from the overall statistics in IPRs. And what we're seeing is that in 1600, the PTAB has instituted 61% of proceedings on 58% of challenged claims, and that compares to the overall rate of 72% of proceedings being instituted on 64% of challenged claims. And so about a 10% lower rate of institution in Tech Center 1600. And so the first hurdle as a patent owner is to survive the institution decision. And then at the back end, where we have a lower number of decisions, final written decisions, we're seeing that the PTAB cancels 57% of instituted claims in Tech Center 1600, whereas overall PTAB has a cancellation rate of 84% of instituted claims when you look at IPRs as a whole. And so very big difference between Tech Center 1600 and the overall numbers. Trial outcomes. So, out of the 4,100 IPRs that are filed, and as well as CBMs, what we have, so we have 806 final written decisions received, and institution was denied 350% of cases. We have 300 IPRs and CBMs settled post-institution, 162 settled prior to institution, 70 cases where there was a request for adverse judgment by the patent owner, and then we've got a couple more things here where institution was vacated and the case terminated, where the petitioner abandoned the petition. And so we're finally, we're getting a large number of trial outcomes now. So we have that 806 final written decisions received, and we'll tie this in at the end with the number of appeals that we're seeing at the Federal Circuit, which is almost half of those final written decisions have been appealed to the Federal Circuit.
All right, so that's on to me now. So that data that John just showed you there, that was for proceedings that were filed at the Patent Office more than 18 months ago. So they've had a chance to get to the final written decision. But the next few topics that we're going to talk about are things that can really trip you up at the starting line and prevent you from even getting into an IPR proceeding, or we'll come back and you won't find out that you tripped at the starting line until you get that final written decision. And these are things for both the petitioner to look out for and for the patent owner to watch for as well. And if the patent owner sees that the petitioner has made one of these errors, then it's a good chance to stop the trial being instituted in the first place. And the first of these, we'll talk about the statutory filing bars. We've had a few data points from the Patent Office on both of these bars. The first one we'll talk about is the civil action bar, and that's really for a petitioner who filed a civil action challenging validity of a claim in a patent that it then challenges later in an IPR petition. And the point of this statute was to stop forum shopping. And the statute looks pretty clear on its face. Basically, if you first file a DJ action for invalidity, then you're in district court. But there are some minutiae to this statute that we've learned from the board that we just wanted to bring to your attention. So in Ariosa, in that case, the patent owner argued that the petitioner was barred because they had brought a declaratory judgment of non-infringement
and as part of that action had challenged the validity of the claim in a counterclaim. And what we learned from the Patent Office is that they treat, and they looked into the rules of civil procedure and Supreme Court authority for this, but basically an affirmative defense is different from bringing a civil action. So even though bringing a civil action for non-infringement, you can raise an affirmative defense of invalidity later, that's not the same as bringing a civil action challenging the validity of a patent claim. So in that case, the petitioner was not barred from filing the petition. What we see in ANOVA, which is another case, the petitioner had filed 3 civil actions. Yes, and they filed 3 civil actions, and filed really means, in this case, the patent owner had said that it was barred because the petitioner had filed these DJ actions, and the petitioner said, no, we just filed them, we never served them. And the PTAB agreed, because 315A, the language here says filed, and we'll look at 315B in a minute, and 315B says served. So looking right at the language of the statute, the Patent Office says filed does not mean filed and served. So, I mean, typically a civil action isn't triggered until service of the complaint, but here merely filing the complaint in the first place would be enough to bar a party from an IPR. And then lastly, if you have filed a DJ action, which was the for invalidity, which was the case in the Sputamax case, Sputamax, prior to filing the petition for IPR, had dismissed its DJ action without prejudice. And based on Federal Circuit precedents, the board agreed that that leaves the parties as if the action had never been brought. So this is something to bear in mind if you, as an alleged infringer, have decided to start off in district court and you have filed a DJ action for invalidity. You can dismiss that without prejudice if that fits your strategy. Then you can still go back to the Patent Office and challenge the patents there. The next bar is the one-year filing bar, and that's the 315B bar that I mentioned. In this case, the petitioner must file its petition within 1 year of being served with a complaint alleging infringement of the patent. The statute doesn't explicitly say civil action, but the board's interpreted it this way. So an ITC action or an arbitration, they don't count for this 1 year bar. Some minutiae on this. In biodelivery services, this addresses whether 315B is modified by the issuance of a re-examination certificate. In this case, the petitioner was served with a complaint more than 1 year before filing the IPR petition. But after the complaint was served, the patent had been subject to a re-examination. And the petitioner contended that because the re-examination can change the scope of the patent claims, the 1 year bar shouldn't apply. The Patent Office said, yes, it still does apply, because re-examination does not result in an issuance of a new patent. It's just merely re-examination, so the 1 year bar does apply here. We haven't seen whether this would be the similar case for reissue, because we know reissue is typically considered to be reissuance of a patent. And we know from PGR that reissuance of a patent can once again open that 9-month window for a PGR of a post-AAA patent. So there's a possibility that reissues may be treated differently under this 1 year bar, but we haven't seen that case yet. Another thing that's good for you to look at, both as a petitioner and as a patent owner, is that it's the earliest infringement complaint filed that counts. So later filings do not restart the bar. In Apple, in the patents at issue, the patent owner had asserted them against Apple in 2010 and then again in 2012. And the Patent Office found that since Apple's IPR petitions were filed more than 1 year after 2010, it was time barred. Now, one thing that's interesting about this Apple case, and we'll talk about it a little more later, is that before the board issued its decisions in this case, it allowed Apple to move for Joinder with another IPR. And that raises an interesting issue that Joinder is not subject to this 1 year bar. So if you consider, if you are outside of your 1 year bar and another petitioner files a petition on a patent that you're interested in, you do have the option to move to join. And we'll talk a little bit more about Joinder later. And the third point here is, like we saw with the DJ action, if you file a declaratory judgment action for invalidity and dismiss it without prejudice, it's as if it doesn't happen. It's not barred under 315A. Similarly, under 315B, if the infringement complaint was served more than a year earlier but also dismissed without prejudice, there's no bar here. Where else can a petitioner get burned right at the start, and what else should a patent owner look out for? It's the real party in interest. We don't really have much guidance on the real party in interest. It is a highly factual, it's a fact-dependent question, and really it comes down to control. The party who directs and funds and controls whether the IPR is filed and what grounds are raised and how it is run. That's really who the real party in interest is. What we've seen are co-defendants in a litigation. Without more, they're not real parties in interest. If you have a contractual agreement that, say, doesn't give you the right to intervene, you're not a real party in interest. And indemnification clauses and purchase agreements, without more, doesn't make an RPI, a real party in interest. But when we get to related corporations, the inquiry is not really whether a corporate entity that's not named controls the listed entity, but whether that unnamed entity can exercise control over the post-grant proceeding. You see a lot of corporate setups where there is a parent corporation that funds every aspect of a subsidiary, and that may not be enough to be a real party in interest. It's more, do they directly fund the IPR and do they control it? And it really comes down to whether your corporate relationship gets blurry, and that's where the Patent Office is weighing all the facts and finding out whether there's a real party in interest. Why is it important whether there's a real party in interest? Well, if you don't list the proper real party in interest, excuse me, you can lose your filing date, and that can be important. So, oh, sorry, let's go through. I have some cases here. That can be important as to your filing, because so if you do not list all the real parties in interest, the Patent Office can allow you to refile your petition to correct the issue, and you must update your mandatory notices. But if it results in a new filing date, that can be critical to a case that's come close to the one-year statutory bar that we were just talking about. And in the Velio case, Velio had a near miss on this. They filed their petition the day before the one-year bar, and there were a number of entities listed on the petition as real party in interest. And after really 7 months before filing the petition, some of the successors, the company names had changed. So the patent owner challenged this issue with the board, and the board authorized briefing on the issue. And really what this one came down to was, it was merely a name change. That the correct entity under its previous name had been listed as a real party in interest, and the board saw that to not really be a substantive issue. So they allowed Velio to keep its original filing date, which was important because had Velio lost that date, it would have been barred under 135B. And we see that happened in the Corning case. In Corning, the board instituted IPR of 3 patents. Now these petitions were filed very much less than a year after a lawsuit was served against the petitioner, so there was no initial threat of a 315B bar time. But the patent owner argued that the petition was not entitled to its original filing date because it had not listed all real parties in interest. And following additional discovery, the board ruled on this and determined that the Corning entities should have been named as real parties in interest. They found there was sufficient commingling between the unnamed entities and the named entities, such that they should have been named. And then instead of allowing Corning to refile, the board pointed out that had they done so now, we would be past the 135B bar date. So they just terminated the proceeding. So it is very important to list your real party in interest. You don't want to trip at the start line for failure to list all possible involved entities. So it's worthwhile making sure your outside counsel knows the different corporate entities that may be involved. And as a patent owner, when you see a petition filed, if you have any inkling, real party in interest, not everyone is listed, we find that if you meet the garment standards, the board has been typically giving discovery on this issue to patent owners in order to determine if the proceeding should go forward. And they're giving it prior to institution, in some cases. In most cases, they're waiting until post-institution, but we're seeing the discovery being given out. Second bite to the apple. What happens if you have got the first petition wrong and there's not institution, whether it be for a procedural issue or on the merits? How many times, there's no estoppel on a decision to not institute, so how many times can a petitioner refile petitions for IPR? Really, initially, this was happening frequently, and now the Patent Office, given the volume of filings, it's becoming a little stricter in exercising its discretion. And here, the Patent Office has the discretion to reject a petition if it raises the same or substantially the same prior arguments that were previously presented to the office. And there's a lot of factors. Not one of these is positive, and it's really hard to even say a combination of them that's dispositive, but these are sort of the typical things on the slide that the Patent Office is looking at when it's making this decision on whether to invoke its 325D discretion. In general, the PTAB is more likely to invoke 325D against a party that participated in an earlier proceeding, and it can make a little difference if you rely on the same or different prior art. If you rely on the same prior art, the Patent Office is typically just pointing straight to the statutory language. If you rely on different prior art, the Patent Office is giving the petitioner a hard time if they can't explain why this different prior art was not raised previously. The PTAB has also exercised its discretion when a second petitioner is seen to be using an earlier decision as a roadmap. A minority of panels have found this approach permissible, but more typically, the panels are refusing to consider this second bite of the apple, as they say it. So really, if you have received a decision on non-institution, things to consider are, if you're going to file a second petition, take the 325D issue head on and explain to the Patent Office why the second petition is not the same or substantially the same. And another thing to consider is, again, the opportunity for joinder if you're a different party from the first party. So joinder, we'll move on to that now, it's also discretionary. And here, a patent owner may request joinder via a motion. And it's typically no later than 1 month after the institution date for any IPR for which joinder is requested. And typically this happens, as I said, a second petitioner files an IPR simultaneously with a motion for joinder. This is a useful strategy if you've been time barred, because by service of a complaint for infringement, because the 315B bar, as we mentioned, doesn't apply to joinder. So consider this as a petitioner. If you're a co-defendant in a litigation and you file an IPR, even if your defendants are time barred, if they were served earlier than you may open the door for them to join you at the IPR table, which is often a good segue into settlement. So you may be opening the door for more people to join your settlement discussions. Now, of course, they have to successfully move to join and do so typically within the 1 month time frame, but at least you've opened a door. So really, what are the things that the Patent Office has looked at for joinder? You can't join another proceeding if that first proceeding has been terminated, and that's simply because there's nothing left to join. And then under certain circumstances, you're supposed to file the motion to join at the same time as you file the petition, typically. But we've seen one instance where that wasn't required, and that was in the Apple case that we talked about earlier, where the board allowed Apple to file, although it had filed a petition much earlier in the proceeding, it had missed its 135B date because it was looking at the wrong complaint. And the board allowed Apple to later file a motion for joinder and join a proceeding that had been instituted on the same patent. So this was a kind of a lucky out for Apple. I haven't seen any other cases where anyone has been allowed to do this so late in the game. There are some circumstances that the 1 month time period can be waived. Talked about this with Apple. But in one case, in a Sony case, for example, trial was instituted in May, and Sony did not file a petition with a motion for joinder until August. Patent owner said that was too late. But in the interim, another party had moved to join the initially instituted trial, and that decision had been granted, and that IPR was instituted. So the board found that since Sony's later petition was in 1 month of that second joinder, they allowed it to go ahead. So one thing that we've also learned about joinder, and this was an expanded panel decision in target maternity, and this really flip-flopped board practice for a lot of people prior to this decision. And as you know, or if you don't know, these decisions are all panel specific and not binding on any other panel, which is why we see some inconsistencies with the Patent Office. But really prior to target maternity, we had seen panels joining issues. So one party would file a second IPR to add additional issues, and the board, certain panels were joining that. Others were not. The target maternity was an expanded panel decision that sort of made it clear that joinders for joining parties, not for issues. And that's been followed up and cited in several other decisions where we're seeing that trend now, joining parties is issue. With that, I'll move on to Jeremiah.
Thanks, Deb. Now we're going to turn from some of the threshold considerations for petitions to the substance of your invalidity attack, prior art. Recall that IPRs are limited to challenging novelty and obviousness of patents based on clinical applications, for prior art patents, published applications, technical manuals, journal articles. What happens if prior art is not prior art, but is instead intervening art or qualifies only as prior art under 102A to the earliest priority date by a few months? It could be 102B with a prior art attack. Well, one strategy used is to challenge the priority date to which a patent is entitled. Now, to effectively claim priority to an earlier non-provisional or provisional application, the earlier application must both describe and enable the claimed invention of the target patent. Typically, a petitioner uses this approach to increase the pool of available prior art. Sometimes intervening art can present the strongest basis for challenging the patent claims in an IPR. If you look at the slide, so far in IPRs, we have seen the PTAB address priority challenges in 63 institution decisions and 7 final written decisions. Of the 63 institution decisions, about half have been successful in priority challenges. But in the final written decisions, all 7 have thus far been successful. Because IPRs are limited to challenging novelty and obviousness, this may seem like a prohibited 112 first paragraph challenge to the issued claims, but it is not. The PTAB has sanctioned it. All benefit claims are open to severing, including those under 119 for provisional applications or under 120 for continuations or continuations in part. Now, where priority challenges have not been successful is when, for example, the same 112 first paragraph issue was raised during prosecution and claims were allowed over that same issue. This is the Prism Pharma case. And institution was denied in that instance. However, the PTAB has allowed priority challenges where similar 112 first paragraph arguments were raised in a related application, but the scope of the claims and the patent differed significantly from the related application. And this is the Daiichi Sankyo case where they granted institution under these facts. The rationale for allowing priority attacks in the continuation scenario arises from the Federal Circuit's 2012 NRA NTP decision. While that case involved an inter-parties re-examination where the requester had attacked priority in a straight continuation scenario, that is, where the text of the priority application and the challenge patent were presumed identical, the PTAB has cited NRA NTP as a source of authority. NTP's rationale is that to claim the benefit of an earlier filed priority application, the issued claims must have 112 first paragraph support, even if the disclosure is identical. There's no presumption that an issued claim is entitled to the earliest filing date in the patent family. But priority challenges are not limited to increasing the pool of available prior art in IPR petitions. For example, a priority challenge in the context of a PGR can make an otherwise PGR ineligible patent eligible. By law, post-grant reviews are limited to patents issuing from applications filed on or after March 16, 2013. That is, where the challenged patent contains or contained at any time a claim to a claimed invention that has an effective filing date that is on or after March 16, 2013. In the simplest case, if the earliest filing date of the application is on or after March 16, 2013, then the issuing patent is PGR eligible. However, where the earliest filing date is before March 16th, but the actual filing date of the patent application is on or after March 16th. These are sometimes referred to as bridge patents. Then to make such patents PGR eligible, you need to attack the benefit of any claim, whether issued or pending during prosecution, to the pre-March 16, 2013 filing date. As of the end of last year, in the 14 filed PGR petitions, 7 had challenged priority by contesting the earliest effective filing date of at least one claim in a bridge patent. And the PTAB recently instituted PGR on a bridge patent in the Guran v. Premium Genetics case. So there, the priority chain extended over a decade of continuations with identical disclosures. Thus, the attack was really on the sufficiency of disclosure for the issued claim, where the same specification was used in each con. Now, the PTAB specifically considered the statutory language that the patents contain or contain at any time a claim, and addressed the patent owner's argument that the effective filing date analysis is not warranted at the institution stage in a PGR, just because the PTAB has permitted it in the context of IPRs when assessing whether intervening prior art is applicable. In response, the PTAB said that we're not persuaded by the patent owner's distinction between an effective filing date analysis of a challenged patent and a decision on institution of IPRs for establishing a reference as prior art, and the effective filing date analysis of a challenged patent and a decision on institution of post-grant reviews for establishing standing. The patent owner also argued that it was unfair and inefficient to assess the effective filing date at the institution phase because petitioner is permitted to present expert testimony, whereas the patent owner ordinarily cannot at that stage of the proceeding. And the patent owner said the standing issue should not be decided on such an unbalanced record. But the PTAB responded that they weren't persuaded and stated that the patent owner could challenge standing after institution with supporting testimonial evidence in its patent owner's response. So for those looking to challenge patents, this decision may open up your competitor's patents to PGR attack and provide another tool to clear freedom to operate. But it behooves those prosecuting patent families that have a change of priorities bridging the March 16, 2013 date to take a very deliberate continuation divisional strategy, especially for key patents to important technologies. And the decision is particularly relevant in the pharma and biotech industries, which file a large number of continuations, typically, and may have transition patents that emanate from applications that at one time had a claim pending that was allegedly overbroad and thus not entitled to pre-March 16, 2013 filing date, and may be more susceptible to attack on grounds outside of novelty and obviousness, such as 112, patent eligibility under 101. So it's an important consideration. So now let's turn from the challenge patent to the prior art. It's also been a commonly held belief that for a potentially invalidating prior art reference to be entitled to the filing date of a provisional application, that the provisional application itself must contain the same invalidating disclosure. In other words, it's been believed that if a provisional application contains an invalidating disclosure, any patent claiming priority and containing the same, although not necessarily verbatim disclosure, as that provisional, will be prior art under 102E as the provisional filing date. Almost 25 years ago, and in Ray Wertheim clarified that a reference patent is only entitled to claim the benefit of the filing date of its provisional application if the disclosure of the provisional application provides support for the claims in the reference patent in compliance with 112, first paragraph. Now last year in Dynamic Drinkware, the Federal Circuit reaffirmed Wertheim, confirming that it's not enough to have support for the relied upon disclosure in the earlier application, but it is the claims of the relevant patent that are important. As the Federal Circuit put it, a provisional application's effectiveness as prior art depends on its written description support for the claims of the issued patent of which it was a provisional. So in Dynamic Drinkware, the petitioner did not compare the claims of the prior art patent to its provisional application to demonstrate that the prior art patent was entitled to its earliest filing date under 112 first paragraph. And the PTAB instituted IPR, but in the final written decision found that a prior art patent was not prior art under 102E2 because petitioner did not meet its burden of demonstrating the patent was entitled to its earliest filing date. And there the PTAB relied on 119E1 and holding that the disclosure of the provisional application must describe and enable the ordinary artisan to practice the claims of the non-provisional in compliance with 112 first paragraph. So just last month, the PTAB has issued some additional final written decisions that reiterate and expand upon these issues. In the VMware proceedings, the decision follows Wertheim and Dynamic Holding that a prior art patent that claims benefit of an earlier filing date through Section 120 as well as 119E requires that the claims be supported by 112 first paragraph in the non-provisional or provisional, respectively, and held that a prior art patent is not prior art in a final written decision where the petitioner failed to demonstrate claims of a 102E2 patent had 112 first paragraph support in earlier provisional or non-provisional applications. It's the second decision here, the Ariosa decision, where the PTAB extended the Wertheim drinkware rationale to a prior art published application that qualifies as prior art under 102E1. In Ariosa, the PTAB saw no distinction between 102E1 and 2 for purposes of 119E. That is, 119E does not distinguish between prior art patents or published applications, and the PTAB held that the challenge claims were not unpatentable where the petitioner failed to demonstrate the published application had 112 first paragraph support in the earlier application. So these decisions reinforce the importance of showing not only how the challenge patent claims read on the prior art patent or application and its earlier filed application, but also how the prior art patent or application claims read on its own earlier filed application. So there's one mistake that a petitioner can make in a petition that may not trip them up until the finish line is at sight. As you know, the petition is really the only opportunity the petitioner has to prove its case, and that includes the evidence needed to meet the petitioner's burden. Post-grant proceedings are subject to the federal rules of evidence, so always bear that in mind when reviewing the evidence cited by a petition. The patent owner gets an opportunity to object to all pre-institution evidence, that is everything in the petition, within 10 days of the institution window. Don't miss that window. And if the evidence is flawed, object to it. The petitioner will have an opportunity to cure, but if they don't take the opportunity or don't adequately cure the flawed evidence, then the patent owner can move to exclude the evidence once all briefing is complete in the proceeding. The same ability to object to evidence applies to every substantive paper filed after institution. But it was the flawed evidence in the petition that killed the case in TRW Automotive on the slide. There, all grounds in institution relied upon a reference, which the patent owner moved to exclude as unauthenticated. The PTAB granted the motion, and the petitioner's case simply fell apart, with the PTAB confirming all challenge claims in a final written decision with that reference removed. So when preparing your petition, don't leave anything to chance, and be sure to properly authenticate your evidence. Now moving on to lessons learned about the AIA PTAB proceedings that come from district court or from federal circuit. It's been said many times and many ways now that a decision on institution is not appealable. No one has challenged successfully the decision denying institution. The Federal Circuit has dismissed every appeal on this, even those on standing. District courts have followed suit. The only recourse is to request reconsideration of the decision. However, given the minimal request for reconsideration granted to date, it seems that once a decision on institution is made, it's typically set in stone. But keep an eye on the in re quoso appeal now before the Supreme Court, which has been asked to decide whether the decision to institute is judicially reviewable.
And so states, a high number of IPR filings have concurrent litigation in district court. And what are we seeing there? District courts are generally granting stays, but they're waiting until after an institution decision from the PTAB. And so the timing of the request for a stay is important. And so we've seen 310 stays granted by district courts, 88 stays denied. And so it's not a given that you'll get a stay, but these numbers are much better than what we had seen in the context of inter-party re-exams, where district courts realized that the Patent Office was not moving those re-exams quickly, whereas IPRs, the district courts are recognizing that a final decision will be soon forthcoming.
All right, so another hot button is Estoppel, and this has always been something that's been a little, you know, people are interested to find out what's happening in Estoppel. Since we've got to the point now where we have final written decisions, we can start to see what happens to a petitioner who has lost, or to a patent owner who has lost in an IPR, in other proceedings, how this estoppel is being treated and where it's kicking in. So the estoppel analysis, it's relatively simple when you're considering your unpatentability grounds or types of prior art that are statutorily precluded in IPRs. Basically, as we've told you, the IPR petitioners can challenge patentability only on anticipation and obviousness grounds, but they must be based on prior art patents or printed publications. So regardless of an IPR's outcome or final status, the plain language of the statute doesn't preclude a petitioner from challenging a patent claim in district court on grounds that they couldn't have raised in the IPR, such as 101 or 112. And likewise, an IPR petitioner is not stopped in district court from relying on prior art that is not a patent or a printed publication. We see this in the red line detection case, and in that case, the PTAB concluded in its final written decision that Redline had failed to show that the challenged claims in Star's patent were unpatentable. And there was a district court litigation going on in parallel, and there Star moved to strike Redline's invalidity contentions based on the 315E2 estoppel. Basically, Star argued that Redline reasonably could have raised prior art, a particular prior art reference in the IPR, but this reference, and I'll put air quotes around that you can't see, it was actually a physical machine. It wasn't a patent or a printed publication. So the district court noted that the machine was, A, not a patent or printed publication, but it also provided additional disclosure over and above the machine's instruction manual, which had been one of the printed publications used in the IPR. So in this case, the district court did not apply the estoppel because the physical machine could not have been raised as prior art in the IPR. And we've seen another data point from a district court from Texas this time about a pending IPR that hasn't reached a final written decision. There's many district courts, as we just saw, are granting stays of litigations pending the final written decision. So we have only a few data points here. But this one district court has implied that an IPR petitioner would be stopped from relying on a prior art references used in a concurrent IPR, even though that IPR hadn't reached a final decision yet. That's the Inventus case there. And the court there said, I mean, they didn't impose the estoppel, but they did mention that the defendants will be stopped from asserting the roughly 14 prior art references raised at the PTAB. They will not be stopped from relying on the roughly 200 additional references that they've raised in this litigation. So that went forward. So when the PTAB denies an IPR petition, that proceeding ends without a final written decision, and therefore the estoppel shouldn't apply. And indeed, we see this in National Oil Well. There, National Oil Well had argued that Omron was stopped from raising certain arguments because the PTAB had denied Omron's IPR petition, but the district court disagreed and said the statutory doctrine of estoppel doesn't apply here. There was no final written decision. Then what do we see at the PTAB? We've seen some estoppel decisions from them. In Dell, after a final negative or a negative final written decision, a petitioner filed a second IPR asserting that, excuse me, one of the references that they had used as part of a 103 rejection in the first IPR actually anticipated certain claims and should be raised under a different ground. But the Patent Office saw this squarely within the estoppel provision and did not institute that IPR. And then in FDI, another case from the PTAB on estoppel, an earlier IPR proceeding had found a subset of Bose's claims, including the independent claims, unpatentable based on the same prior art asserted in the second proceeding. And the second proceeding was directed to claims that depended from those independent claims that were found unpatentable in the first proceeding. The petition argued that the patent owner was stopped from arguing any patentability or admissibility issue that was decided in petitioner's favor in the prior proceeding. But the PTAB disagreed, and they relied here in a discussion that accompanied the final rulemaking that the estoppel applies against a party whose claim has been cancelled, not merely held unpatentable. And here, this decision fell right in the window where in the earlier proceeding the claims had been cancelled, but the appeal had been found unpatentable. But because the appeal window was still open, they hadn't been finally cancelled. So the board gave this bit of wiggle room between those decisions and allowed this to go forward with no estoppel being enforced. So we'll continue to get more decisions and more guidance on Estoppel, both in district court and at the PTAB, and hopefully in future we can share those with you. Now we move on to the Federal Circuit.
So we'll turn to the Federal Circuit now. First we'll show you some numbers, and then we'll discuss the handful of decisions that are going to impact life at the PTAB. So there are 475 appeals docketed at the Federal Circuit right now for AIA cases, so IPRs and CBMs primarily. So 386 decisions appealed from final written decisions at the PTAB, 67 CBM final written decisions appealed, and then some other appeals, non-final decisions, 22. And we see that primarily there's a lot more appeals being filed by the patent owners, 313 compared to 75 by petitioners. And then we have 43 cases where both parties have appealed with a direct and a cross appeal. We've had a handful of mandamus petitions as well, so 10 in IPR petitions. So there are a large number of cases docketed at the Federal Circuit. You see that from this slide, it's a difficult one to read, but chemistry is towards the right-hand side of that chart. There's chemical and materials engineering, where there's 42 appeals filed, and then 32 for life sciences. So we have 75 decisions to date from the Federal Circuit in AIA appeals. There are 67 affirmances, which is 89% affirmance rate of the PTAB. We are also seeing that a number of the decisions are Rule 36 affirmances, and so there is no written decision accompanying the decision. It's just a one-page affirmance of what the PTAB has done. 7 remands, 1 reversal, and so 8 dismissals and 15 pending. And so what have we seen? 90% of appeals have been affirmed. 50% of those decisions are Rule 36 summary affirmances, and 10% have been involuntarily dismissed. And so it'll be interesting to see if the trend of this almost half of the decisions being appealed continues with a 89% affirmance rate at the Federal Circuit. That may cause parties to maybe not appeal so many cases, but it'll be something to watch out for. And pretty much a summary of what I just said. The court is handling the volume by issuing these Rule 36 affirmances. They're aggressively consolidating related cases. Their target of issuing opinions within 90 days of oral argument, they're holding to that, but it seems like we're starting to see a calendaring backlog of oral arguments and consideration of the appeals. And so obviously the PTAB, PTO has hired a number of judges. The Federal Circuit is not hired to keep pace. So we expect to continue to see a calendaring backlog of parties continue to appeal at such a high rate.
Really, I mean, this could be a presentation in itself, the significant cases that and decisions that we've seen from the Federal Circuit, but we just wanted to bring a few to your attention towards the end here of the presentation. Enrique Rozo was one of the first decisions that we got. Jeremiah mentioned it later. And really, the difference between IPRs and the district court litigation, one of the differences is claim construction, where IPRs and CBMs, PGRs are all done under a broadest reasonable interpretation. And Enrique Rozo answered the question, was that an appropriate claim construction standard? And the Federal Circuit said yes. Now that is before the Supreme Court, so stay tuned for that. But Rozo also informed us for the first time that the institution decision is not appealable, even after a final written decision. And that's been repeated throughout Federal Circuit decisions and in some district court decisions, as we saw earlier. Enrique Rozo also told us that the board is not strictly limited to the grounds raised in the petition. It can raise other grounds sua sponte or modify grounds raised in the petition. The board has the authority to do that. And dynamic drinkware, we discussed earlier the impact of dynamic drinkware on 102E prior art and showing what is 102E prior art and how to do that. But dynamic drinkware also clarifies the burden of production versus the burden of persuasion. And really the burden of production can shift to establish or rebut the prior art status, but the ultimate burden of persuasion stays with the petitioner to prove unpatentability. The petitioner is the person moving for unpatentability. They carry the burden of persuasion. Acades tells us again, an institution decision, even that going to a statutory bar, that's not appealable. So even whether a party had standing to be in an IPR in the first place is not appealable to the Federal Circuit. People have questioned whether the office was right to delegate both the decision to institute and the final written decision to the same panel. Some people have commented that they feel that's unfair to the patent owner from the outset, that it's difficult to change a patent owner's mind, a panel's mind once the trial's been instituted. We can see from the statistics that that's not necessarily the case, particularly in the pharma case, where we're seeing only about half of claims instituted cancelled. But the Federal Circuit affirmed that the Patent Office has the statutory authority to delegate how it likes, and that's what they do. And then this is a case that just came out this week, where it was just an interesting note that in this case, in some cases where the Patent Office or where the Federal Circuit has sent the case back to the Patent Office, it's been for claim construction issues where they believe the Patent Office hasn't applied the correct claim construction. One thing that was interesting about this case is it was sent back to the Patent Office for different reasons, but the claim construction in this case was correct under BRI, but there's some commentary in the case that there might have been a different outcome here under Phillips. So that's good to bear in mind when you're picking your forum as to how important broadest reasonable interpretation can be. So stay tuned for the quozo to hear for sure whether that should be the standard applied at the Patent Office.
Right, so in sum, now that we're more than 3 years into a new post-grant proceeding regime in the U.S., we've been able to collect sufficient data to better understand several aspects of the laws and rules guiding these proceedings and their nuances. But that data collection is nowhere complete, as the Federal Circuit and Supreme Court are just now considering a few aspects of the law on appeal, critical as they are because they touch on, for example, the disparity between the way that an issued patent claim is interpreted before the Patent Office and the courts, as Deb's just referred to the quozo decision, and whether a decision by an administrative agency should be reviewable by a court, which will also be decided. These and other issues, like standing of IPR petitioners, which currently can be anyone, even former patent owners, and eligibility of patents that cover Orange Book listed pharmaceuticals, are also before Congress and potentially another round of patent reform. We expect that patent stakeholders will continue to push for a resolution of these issues in whichever forum, courts or Congress, presents the path of least resistance. For now, at least some of the battle is moving more quickly through the courts, and as these and new issues arise for post-grant proceedings, we expect that IPRs and PGRs will become a mainstay in the pharma and biotech industries and must become an integral consideration when building or attacking a patent portfolio.
So thank you for your attention today. We only have a couple minutes. If somebody wants to have any questions, if we don't get to your questions, we'd be happy to discuss those offline with you. But again, thanks for your participation today, and we look forward to being able to give you the next update on where the law has gone in a few months from now. Thanks.
Great, thank you.
Thank you.